is of no evidential value. Their testimonies did not establish the fact in issue, what they call factum probandum, nor the evidentiary fact, which is factum probans. My lord, again, I've set out in detail the law related to evidence and relied on various case law. And my lord, it's instructive to note that, because basically what they said is hearsay evidence. It wasn't based on any evidence at all. And hearsay evidence is not acceptable, it's not admissible in law. And I invite you, my lord, to reject the evidence of the witnesses, those proffered before you. My lord, Section 106B of our Evidence Act sets out clearly when you're relying on electronic evidence that, what it entails, including the certificate by the person that produces the report. My lord, and there has to be someone of authority. And he must tell us how he managed to access the information, how he managed to produce the report. We're not told where the TV clips came from. We're not told which the person who produced them, whether he had authority, of what authority, not an employee of the lead counsel working in his office, MMC Africa. Again, my lord, I've annexed the entire case law relating to evidence under Section 106B. And you'll find, my lord, that the evidence before you is useless, is worthless. My lord, the issue of conspiracy. You've been told, again, by lead counsel without evidence from here, from the bar, that Commissioner Irene Masit wanted a certain preferred candidate, that there was conspiracy between the commissioners and a political party. My lord, the law relating to conspiracy has two elements, and they are mandatory. There must be agreements of two or more persons. Agreement of two or more persons. Then number two, you must prove criminal intention to execute. So there must be meeting of minds, and then there must be commitment or the conspiracy to commit the crime. My lord, again, I've annexed the case law relating to conspiracy, both Akbolt and our local case law from our Court of Appeal. My lord, it's not enough to allege conspiracy, but the tribunal must show that Cherera 4 had common intention, that their minds were at Eden, and that they jointly conspired to subvert the electoral process. No evidence was shown whatsoever. No evidence was presented before you to show such conspiracy between Cherera 4 amongst themselves, or Cherera 4 and the Azimio leadership, whatever if it was Azimio they're referring to. In fact, the evidence was given, my lord, that Commissioner Irene Masit and Commissioner Wanderi didn't like each other. Chebukati himself told us they didn't like each other, and they're supposed to have conspired. How do you conspire with someone you don't like? That's their own evidence. My lord, I didn't get the evidence of Yaya and Serena until now. I don't get the evidence of Yaya and Serena. We're told Commissioner Irene Masit went in on August 15. No evidence was shown. We're never told what room she was staying in. We're never told when she came out. So we don't know if she went in and disappeared into Yaya Towers, Yaya Hotel. I didn't get the intention of the evidence of Yaya and Serena. My lord, at best it's plain falsehood. I don't know the intention of the evidence. It's meaningless. It's of no evidential value. My lord, burden of proof. You've been told burden of proof is
How much time do you still want?
That it's prima facie, or just prima facie. And then the case law is relying on, my lord, I've gone through them. It's on case of the Judge Mutava, and I've told you there is a distinction between trials of judges and impeachment under Article 51. There's a big difference, my lord. And then it's relied also on a case law on an accident case, running down case claim. You cannot compare an accident claim and impeachment under this article, my lord. Impeachment proceedings are criminal proceedings by any other name, as the outcome either is conviction or acquittal. There is no other way in impeachment trial under Article 51. You either convict or acquit. It doesn't matter the wording used by our constitution. The law as established since 14th century. It leads to acquittal or conviction. There is no other choice. My lord, the lead counsel had the burden to prove beyond reasonable doubt the allegations against Commissioner Irene Masit. My Lord, I've set out the case law on a burden of proof. The leading case law, my Lord, which you are well aware, is the Wilmington case versus DPP of England of 1935. It set out the minimum requirements on burden of proof in any criminal proceedings. And every court in this country, every court in the Commonwealth relies on that case. It's the classical case on the burden of proof. I invite you, my Lord, to read it. And the other case that I've relied on, my Lord. My Lord, the last issue I'm relying on, not the second last issue is, my Lord, is the issue of bias. The issue of bias, again, my Lord, I've relied on 5 authorities. A tribunal sitting, a court sitting, must always reflect on the issue of bias, suo motu or at the application of any party before it. A member of a judicial body must be above suspicion, real or imagined, actual or perceived. Article 50 and Article 160 of our Constitution, my Lord, protects a party before a tribunal from any tribunal that seems to be biased. The case law I've relied on from South Africa, India, and our country sets again the parameters, my Lord, that makes you reflect on the issue of bias. Does the public have confidence in the process? My Lord, the last part of my submissions is the evidence of Wafula Chebukati and Marjan Hussein Marjan. My Lord, I've set out again the issues, but the courts, our courts, have found recently, last month only, that Marjan is unworthy as a CEO of Iebc, that he breaks the law, he acts with impunity, basically does not respect the law. And they said he took sides when the Iebc broke into Chebukati 3 and Cherera 4. The court said as a CEO, he was supposed to be impartial and he was not supposed to take sides. The court found as a fact that he took sides. And I'm inviting you, my Lord, this tribunal is subordinate to the employment court, which is equivalent to the High Court. The High Court has said Marjan breaks the law. He acts with impunity. My Lord, Supreme Court twice has censored Wafula Chebukati. Twice. In 2017 and in 2022. And they say he acts like a dictator. He has no power, such powers that he gave himself, acting as a supremo of Iebc. So, my Lord, the issue is, again, we're told that at 4 p.m., August 15, none of the commission, not even the chairman Chebukati, knew about the results. Marjan walked in with the results, 3-page results he gave to each commissioner. We've not been told where he brought them from. None of the commissioners were involved in the process. Marjan is the one that brought the results to be announced. Was that his role? To tally results, to bring results to the commissioners who didn't know anything at 4 p.m. of August 15? My Lord, again. Then the other issue, my Lord, all these meetings of 3 p.m., 3 a.m., 2 p.m., and 4 p.m., the Iebc Act and rules says minutes must be taken in all meetings of the commission, and the CEO must take the minutes. Mandatory. I've annexed the laws, my Lord, in my submissions. Marjan never took the minutes of 3 a.m., 2 p.m., 2 p.m. and 4 p.m. And they want us to believe what was allegedly said in the meetings when there are no minutes. These are people who come before you telling you that Commissioner Irene Masit violated the law, and then they violated the mandatory provisions of the law. They were supposed to take minutes. They never took the minutes. My Lord, you can't act on the evidence of such people who break the law with impunity, brazenly. I've annexed the decisions of the High Court, my Lord, that condemned Marjan. 2023. My Lord, you're being told that by the lead counsel that Commissioner Irene Masit accepted to take bribes. That is evidence, my Lord. Chebukati was present in the meeting, said she never did. In any event, my Lord, we have no minutes of the meetings. My Lord, in conclusion, my Lord, my submissions are detailed I invite you to look at myself. But in submissions, my Lord, number one, this tribunal is wrongly constituted. As I said, it's constituted as one body instead of being segregated, being the tribunal, the trial, the court trial, impeachment trial court, and then the independent prosecutor. Here is one and the same thing, my Lord. My Lord, this tribunal again has misunderstood its mandate. As I said, it's supposed to be adversarial, but then you said it's inquisitorial, which is not the purpose of this tribunal. The tribunal, again, the lead counsel, instead of being an independent prosecutor, is part and parcel of this tribunal. My Lord, there is no nexus between the petition filed in the National Assembly and this tribunal. Number 5, my Lord, there is no chain of custody of transmittal documents. The documents from National Assembly to the President to this tribunal, there's never been evidence before this tribunal. We've never been told, because there must be a recommendation by the National Assembly that the commissioner be impeached or there be impeachment trial. Imagine we don't have that report before you, my Lord. We've never been given. What we have before you is the report of the parliamentary committee. We don't have before you the actual parliamentary sitting that recommended her to be impeached. So there is no foundation, there is no substrata before this tribunal, my Lord. You are being told to rely on the committee's report and not the parliamentary report, the parliamentary recommendation. That's what the Constitution says, parliamentary recommendation, not the committee's report. My Lord, in the absence of articles of impeachment from the National Assembly, there is no substratum to this petition. The burden of proof was not discharged by the lead counsel. The charge of conspiracy wasn't proved at all. The evidence of the TV clips is hearsay, and the hearsay, of course, evidence of the witnesses must fail. It never met the legal threshold. My Lord, with tremendous respect again, and you'll see in my decisions, the case I've relied on, the tribunal must not take offense when it's being told it's biased. That's the law. It's the nature of event. It's in the course of your work. So counsel parties must always call out a tribunal for being biased or for having the appearance of bias. So I'm again inviting you to look at their own report and see whether there is bias established by this tribunal against the commissioner. And my Lord, again, the evidence of Wafula Chebukati and the Marjan Hussein is tainted. These are people unworthy to be witnesses. To call someone else to step down or to be convicted for breaking the law, when they are consistent serial breakers of the Constitution and the law. The courts have time and again said the two are poster children of impunity. My Lord, the Supreme Court in its judgment did not blame Commissioner Irene Masit of any offense, and you cannot be invited to find her blameworthy when the Supreme Court did not find. My Lord, that will be dangerous. My Lord, in conclusion, I want to take you back again to times of the temple scene of John 8, 9, 11. Pharisees brought a woman who was found in an act. And my Lord, the men who were supposed to be in the act of these women were not present. So they accused her of prostitution. Jesus asked them, he was without sin amongst them, to be the first to cast a stone at her. And Jesus looked down. When he looked up, none of them was there. None of the people were there, were accusing her. And Jesus said, when Jesus had lifted up himself and saw none but the woman, he said unto her, Woman, where are those thine accusers? Had no man condemned thee? He said, No man, Lord. And Jesus said unto her, Neither do I condemn thee. Go and sin no more. My Lord, Wafula Chebukati and the Commissioner Marjan are basically the key accusers against Commissioner Irene Masit. They were present in these meetings, and they want her to be blamed for meetings they participated in. It's like those men bring the woman to Jesus. When they were part of the act. So if there was any blameworthiness on the events of August 15, then Marjan, Gulie, Molu, and Chebukati cannot be saints. You're being invited to separate the commissioners from Irene Masit. My Lord, I have said my part. I leave it to you. You have a dated history, my Lord, and the commissioner and the members. This is the first impeachment trial in this country. You are laying the foundation for impeachment trials in future. You can lower the bar, you can raise the bar. It's up to you. Whether it's up to you to decide how you want to be remembered. As courageous members of this tribunal who will set a strong foundation for impeachment trials in future, or that you run away from the responsibility. That's all.
Thank you, Donald. No more than 10 minutes.
Yes, I'll take the less. Mr. Chair, on the scripture about Jesus, I quote from Ford that the greatest mistake is not to accept your mistakes. In this case, Commissioner Irene Masit does not realize or accept that she violated the Constitution and the law, notwithstanding overwhelming evidence that was presented before the tribunal. On the issue of impeachment proceedings of the President of the U.S. and other jurisdictions, including South Africa, my respectful submissions is that those authorities that was presented and the submissions on that issue is not relevant at all, with a lot of respect, because Article 251 of our good Constitution sets out clearly the process and the procedure to be followed in proceedings as the ones before this tribunal. There's no evidence that there's any breach of the process set out by our Constitution. We cannot borrow from other jurisdictions when our own Constitution is expressed on the process and the procedure. Second issue, in the errors of the tribunal and whether the mandate is adversarial or inquisitorial, I submit again, the Supreme Court settled that issue in the Mutava case. I urge the tribunal to adopt that position that settled that issue by the Apex Court. My learned friend's submissions is not supported by any law, and I submit that the jurisprudence is well established on that issue. I urge the tribunal to adopt the position by the Apex Court. Thirdly, the issue of res judicata and stare decisis, with respect, Mr. Chairman and members, the Supreme Court set out in page, I believe, 5 of its decision, petition number 5, and it set out 12 issues for determination. And those are the issues that were determined by the Supreme Court. A reading of all those issues with a toothpick is clear. None of them address the issue of removal of any of the commissioners of the Iebc pursuant to Article 251 of the Constitution. And therefore that argument cannot stand in any way at all. Further, there is no evidence that has been presented to show that any court anywhere within this great republic addressed the issue of removal of the commissioner or any of the commissioners pursuant to Article 251 of the Constitution. And therefore, the issues before the Supreme Court are distinct from the issues that are before you. My Lord, there's the issue of the presidential results pathway. I've gone through the submissions on that issue, and I submit that, yes, he submits that there are 14 mandatory steps, and then submits from the bar that there was no compliance. My respective submissions, the issue of the validity of the elections, and the issue on whether Iebc followed the law, and thirdly, the issue of the validity of the results is not within the jurisdiction of this tribunal. Those were issues that were determined by the Supreme Court. And therefore, raising those issues before the tribunal is, with respect, misplaced submissions. As relate submissions on jurisdiction, Chairman and members, Part L3 at page 32 of the Commissioner's submissions, she addresses the issue of submission, on jurisdiction rather. A reading of that part, she only cites the law in respect of jurisdiction, but at no point has she made any submissions to show that the tribunal is working outside jurisdiction. And there is no evidence that was presented to demonstrate that this tribunal was working outside its jurisdiction as required by Article 251. And therefore, I submit that issue is misplaced. I not even quote the case of Mary Wamboi versus Peter Kingara. I had the privilege of arguing that case all the way to the Supreme Court. I'm well aware of the facts of that case. Those facts are distinct and not relevant before this tribunal. Mr. Chair and members, looking at page 36 of the submissions, and which my learned friend has also made arguments on this morning, and on these arguments, he purports, or the inference from the argument of the submissions is there is an attack on this tribunal. And this first attack, and you notice even in the submission they say that the Supreme Court and those sitting in impeachment must be above reproach like Caesar's wife. And we are aware on the day the last witness, my colleague purported or attempted to attack the tribunal or members. And my submission is, as counsels, either lead counsel or counsel for a commissioner, you cannot take advantage of your position and throw unsubstantiated facts to attack integrity or to make allegations of fact which are not substantiated. If my colleague wanted to do those issues, he should have taken the witness stand and presented evidence to support all what he's saying. With the respect, I urge the tribunal to disregard all those submissions or intention to intimidate the tribunal with unsubstantiated facts or who is related to who is on which party. There is no evidence, no affidavit, nothing whatsoever before this tribunal. I urge the tribunal to disregard that argument. As regards incompetence, counsel also seeks to give facts from the bar. Paragraph 149, paragraph 155 of the judgment is very clear in terms of what was the holding of the court. The wise thing would have been for the commissioner to take the witness stand and give the evidence my learned friends seeks to now purport to do in terms of facts. I submit that the issue of incompetence has not been rebutted, and that evidence is not challenged in any way whatsoever. My learned friend also argues that the evidence is hearsay, before presented was hearsay evidence. With respect, Rule 14 of the tribunal rules are clear. The tribunal shall not be bound by strict rules of evidence, but shall be guided by the rules of natural justice. The evidence of Mr. Wafula Chebukati and the evidence of two former commissioners and the evidence of the current CEO of Iebc was primary evidence, not secondary evidence. It cannot be equated as hearsay. They were present, they saw what happened, and they corroborated each other in terms of the allegations that we've presented and before you. They cannot be said to be hearsay evidence. The wise thing would have been for the commissioner to take the witness stand and rebut. She did not rebut any of those evidence of fact however serious they are, and therefore they were not hearsay, and we submit they are unchallenged. He further submits that the evidence, there was evidence from Yaya and Hotel and Serena. And we also reiterate on this issue, the commissioner did not rebut the evidence on that, on what occurred in those places. Did not rebut the evidence that there was meetings with part of the political players from one political divide, and that evidence was presented. She did not rebut it. And it is our respective submissions that evidence.
My Lord, with tremendous respect, there was no evidence like there was a meeting between her and the people from our side. Evidence was laid to show that the vehicles went in. No evidence was shown that there was a meeting, my Lord.
My Lord, Mr. Chair and members, there is evidence that specific people who are aligned to one political divide, and there's clear evidence on that, went to the rooms where the commissioner and others were staying. She did not rebut that evidence. She did not rebut it. And therefore, that evidence is unchallenged. The Article 81, Roman 5, provides the principles, and those principles are applicable. One is impartiality and neutrality.
Your time.
Very well. I'm just ending. Two more. We submit that evidence shows clearly breach of Article 81(5). Second last, there is an attack on the good CEO, Mr. Amarjan. I submit with respect, it's very regrettable for such an attack to come from council. That attack ought to have been through evidence by the commissioner, not council. I urge the commission, the members, to disregard that attack. Lastly, it is my humble submissions that there is overwhelming evidence to prove 3 of the grounds for removal of Commissioner Irene Masit under Article 251(1) of the Constitution. My Lord, Mr. Chair and members, I'd wish to lastly quote Numbers 32:23, where it says, "Be sure your sin will find you out." In this case, Commissioner Irene Masit was called out by her colleagues, commissioners and chair. Her sins found her out, and she opted not to challenge that. We submit the proper recommendation is for her removal. She is not fit at all to be a commissioner of an independent commission, as is Iebc. And we rest our case. Thank you.
Thank you, learned counsel, Mr. Munge and Mr. Donald Kipkorir, and thank you, Commissioner Masit, for your patience to sit through these proceedings. I want to thank my colleagues, members of the tribunal. I want to thank lead counsel and your team. I want to thank Donald Kipkorir and your team. Thank Commissioner. Thank the Secretariat. Thank the press for making sure that we were live throughout these proceedings. We promised when we began, at the point when we were being sworn, that we would be an open tribunal, transparent tribunal, and that Kenyans would real time follow these proceedings. I think we've done that, and the press, thank you very much. We will retire as members of this tribunal to consider the evidence that was before us, tendered before us, consider the submissions, consider the law, and consider the Constitution, and find out what kind of recommendation we will give to the appointing authority in relation to the task that was given to us through the appointment. Yes, there have been criticisms, including Council asking us to deal with our conscience in this matter. I think on our part, we consider that every criticism that there was went to enrich this process, and it will not be taken in any other manner. Democracy, the rule of law, and all the attendant issues are always difficult issues, and they are usually work in progress. And so it is in that light that we take whatever there is that has been said about this tribunal. We wanted it to be participatory, and so every comment that has been made has been part of that public participation in just making us arrive at what we hope will be a reasonable conclusion. So we will retreat. The work of Commissioner Munge and the work of Donald ends here in this room. We wish you well in your future undertakings, because you play no other role. But we thank each one of you for enlightening us on the many issues that confronted us. We wish you well. Thank you.
We thank.
Date for judgment. You haven't told us when we're coming back for judgment.
The law, the Constitution, and everything else says that we report to the appointing authority. I don't think it says that we come here and we tell you what our recommendation is going to be.
I appreciate it.
Thank you.